Before we begin, we wish to acknowledge the lands on which the university operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit. Today, this meeting place is still home to many Indigenous people from across Turtle Island, and we're grateful to have the opportunity to work on this land. Almost 50 years ago, a group of idealistic law students rose to the challenge of providing much needed legal services to low-income Torontonians. That original spirit of improving access to justice carries on with the students that step into DLS today. Together, we can work to preserve and enhance DLS as the premier community-based clinical legal education program in the country. Whether it's securing housing, preventing deportation, or avoiding a criminal conviction, U of T law students have a keen appreciation of the impact their work can have on people's lives and are tireless in their advocacy. This is especially true in the family law division. The pandemic has brought on significant challenges, communication difficulties with former spouses and partners, challenges focusing on the best interests of the children and trying to stretch financial resources further than ever before. Notwithstanding these challenges, the Family Law Division at DLS continued its work uninterrupted. We've assisted clients in pursuing and defending their rights by way of negotiation, mediation, and litigation. In terms of court work, the division has conducted conferences, motions, and several trials during the pandemic utilizing Zoom. Pandemic or not, family law work at DLS continues. Today, I am delighted to welcome three of my professional colleagues to share their expertise on family law through today's presentation. Dana Rotenberg is a manager of PBSC's Family Justice Center. After practicing family law in Toronto, Dana joined Community and Legal Aid Services Program as review counsel, where she was responsible for developing the family law division in response to the immense need for quality family law services for persons experiencing barriers to justice. Richard Teicher supervises the family law division at Downtown Legal Services. During his career, Richard has practiced with a large Bay Street firm, a boutique family law firm, and has run his own private practice. In 2018, Richard was selected to be a member of the Dispute Resolution Office panel for the Superior Court of Justice in Toronto. And we have Roslyn Tsao. She's the managing partner at Epstein Cole and has appeared on motions, conferences, and trials in the Ontario Superior Court of Justice and argued appeals at the Ontario Court of Appeal. Roslyn is also an associate chair of the University of Toronto Tribunal Trial Division for Academic Disciplinary Matters. Just a quick housekeeping note, questions will be held until the presentations conclude, and I'd like to thank Dana for acting as today's Q&A moderator. Thank you, Dana, Richard, and Roslyn. We so look forward to your talk today.
Thank you so much, Prasanna. Good afternoon, everyone. So just before we get started, I should just let you know what it's going to look like today. We're going to have an informal discussion about some of the issues that have arisen during the pandemic with respect to family law. It's going to be, like I said, more of an informal discussion, no PowerPoint today. And just a general disclaimer, because we're lawyers, this is what we do. What we're going to talk about today is general legal information. It's not legal advice. So if you're experiencing any family law issues, it's always best to speak to a lawyer about your particular situation. So on that note, one of the issues that I know has come up a lot at our clinic, the Family Justice Center, and I know in the profession it's come up a lot, is what happens when separated parents see or approach the risks of COVID differently. So whether that be how they conduct themselves when they have the children or not, whether the children wear masks when they're at the playground, all of these disputes that have arisen. Maybe Richard, do you want to touch on that?
Thanks, Dana. I think what I'll start with is people have worked very hard to either have agreements with their former partners or obtaining court orders with their former spouses or partners. And those agreements, contracts, and court orders should still be respected and adhered to during the pandemic. The pandemic doesn't change that fact. And anyone who wants to come to court to change an agreement or a court order, they better come for a very specific purpose and not use the pandemic as an opportunity to change everything that has been decided in their case. So if there's a problem with respect to a parenting issue or a parenting time issue, that's fine. But you should really come with a very specific problem in mind and be very clear about what your intentions are if you're going to challenge or try and alter any court orders or agreements. But that being said, when parents disagree about what to do about time or decision making, the ultimate test is always, and has been for a very long time, what's in the best interest of the child. The pandemic doesn't change that. It's still the statutory test, and it's still the test judges look to if they're going to vary or change any orders or agreements. And when we look at that test, I think it's important for people to focus on, it's not, again, a parental rights analysis. It's about what's best for a child. And we know during COVID times, reasonable people can disagree about what's best for a child. We know that, if someone's acting recklessly or not adhering to the public health requirements, the court will have very little time for them. But if you actually have a reasonable concern that you can't deal with your ex on, the court is open to you. I would say, best interest now has been expanded somewhat because these are unique circumstances. The pandemic, COVID-19, the court is dealing with new issues that it hasn't necessarily seen before. But again, some of the tests that people have to undergo to go to court or be successful at court are the same tests as have always been the case. And remember, the court's not going to throw out your old agreements or court orders lightly, right? So I guess my question to Roz is, what should happen, Roz, if people do have a disagreement with their former partners?
Yeah, so thanks, Rick. I want to approach this on a very practical basis, because in COVID, what we have learned as lawyers trying to represent clients is that the courts were not equipped to deal with COVID, that it's a blunt instrument. And as Rick says, reasonable people disagree during COVID. So they may disagree about how much time your children spend with other blended family members. So we have that. If you think about both separated or former spouses have new families, and then there are children that may be going back and forth there. Those are reasonable concerns in terms of exposure to COVID, especially at the beginning. And yet people can tend to get polarized, can tend to throw out the window what they had before, which was a very reasonable co-parenting situation. So on a practical level, I think what parents need to do is to think about the issues from the other person's point of view and give a benefit of the doubt and say, you know what, okay, I see where there may be some concern here about what I'm doing or what my concern about what they're doing. How do we make it work? Because you don't want to put the children in the middle. It's hard enough for children to be in COVID, but add to it, they have parents who are trying to navigate through it. So one thing is to talk. And I think what I've seen is there are a lot of emails flying back and forth. There's a lot of our family wizard flying back and forth. And sometimes this may be the time when parents have to either pick up the phone and talk to each other and really understand what the concerns are. It's not that you're going out to restaurants, it's that you're going out to restaurants with 6 other people, or that you're going to see grandma and grandpa but you haven't been vaccinated or they haven't been vaccinated. So try and figure out those things. Because if you can't work those things out and you expect the court to do that, it's very hard for the court to do that in a very timely way. The other thing is, if you're going to talk to a lawyer or your lawyer about it, and be prepared, because your lawyer may well tell you that what you think is urgent or critical is not. And you ought to listen to the lawyers. One thing we've learned on this, every day we read decisions from the court, and every day we see what's been happening. And we have a pretty good temperature on what the courts are going to consider to be something that they need to weigh in on, or that they're going to actually just say, we can't deal with it right now, we're too stretched. And so at the beginning of COVID, and even now, there was an urgency test that came up as into whether you can get into court at all right away. And that urgency test was always hard to begin with, but during COVID, it became even more so. You have to also consider, I guess, very practical circumstances that affect parties right now, like, are there family members or other members who are immunocompromised? Was one of the parents a frontline worker who's exposed to COVID? Those are things that shouldn't be used as weapons against the person. They should be also, you have to think about how do we accommodate that? So in cases that I've had over the past year and a half or so, sometimes we look at changing the schedule, which used to be alternate weekends or a 2-2-3 or 2-5-2, to making it more block time, 7 days, 7 days, 14 days, even 14 days, because then you would have some assurance from the other parent that for the 5 days before the exchange, we're not going out to see anyone. We're not going to school. Maybe we'll do online schooling for those 5 days if you had that option, but letting go to school. The whole schooling thing is I think has worked itself out in the sense that schools have had to do both online and in person. So initially that was a very sort of contentious issue as well. If there is serious behavior that is a problem, then for sure the courts are there for a reason. So if you have a parent who is traveling in and out of the country, not quarantining, and then wanting to exercise access or parenting time with the children, then you may need to get in there, because there may be a lack of insight about exposure or about danger in that sense. And that factors into best interest of the child from a purely physical health point of view, and the health of the other parent and the health of the other people who interact with the child. So I'll finish on just, you want to think creatively about things. There's rapid testing now that you can actually purchase privately. Maybe you do that. I know we didn't want to expose kids to the nasal swab, but the rapid testing is a little less, let's say, intrusive. You have to feel comfortable, and people have different levels of comfort. It doesn't mean it's all opportunistic, as Rick says. It may just be how people feel, and people have felt a lot of different things during COVID, and I think we need to respect that as well and try and keep the kids out of it if we can.
So I'll just say one thing with respect to what Roz says is, keeping the kids out of it is always a great idea. I know the kids are the number one concern, but a lot of these are adult discussions that shouldn't properly involve the children, and any discussion or conflict should be between the parties and not with the children. That's not to say the children won't have a voice in this. They may have a voice, but not a party to the conflict. But speaking of conflict, the piece I wanted to raise next is about domestic violence. And we've seen in the media, there seems to be a discussion that the frequency and severity of domestic violence during the pandemic time has increased. There's a lot of concern about the safety for victims of domestic violence, and how are those individuals being served during this time, and sort of what is our experience collectively with respect to this issue. I'm wondering if Dana, you can speak to this a bit.
Yeah, absolutely. So Richard, just as you're saying, I'm sure we've all read news articles about the spike in domestic violence across Canada, more globally, during COVID. And I mean, just to break it down, it might be apparent, but when you think about what's been happening, it sort of connects the dots. So sheltering in place has created a lot of challenges for families. That's probably an understatement. Children may have been home from school or daycare. People have multiple children, perhaps living in a potentially small space. People have lost their jobs. There's been income loss. Families are being forced to remain in a space and a home together when that might not have been the case prior to COVID. So all of these factors and more, create a lot of stress and anxiety, and tensions are raised. And we know that these things impact behavior. So all of these things could exacerbate or create problematic or abusive situations for people. But even with all of these increased stressors, people might not feel like there's a place to turn during COVID, which leads to a lot of isolation. So, you can't just go for a walk with your friend in the same way, or go visit your sister to talk about what's happening. And that's creating a lot of isolation. And even in terms of social services, whether it be counseling or agencies or even shelters, there's limits to accessing those. So even though some services are absolutely offered virtually, I think there could be challenges accessing those services. Whether you have proper internet service is one thing that I think we take for granted sometimes. And also the ability to just pick up the phone and speak to someone and have the requisite feeling of privacy when your spouse, the potential abusive spouse, is in the house at the same time, not getting that space to even make a really important phone call to reach out for help. So obviously this isolation and the lack of resources can be quite detrimental. And as I said, even though there are services that are available, and some of them I'm going to post after I finish speaking, but even though they're accessible virtually, they might not feel accessible to people who are experiencing violence, because they might feel as though they're watched in a way that might not have been the case before. Maybe before they used to be able to go and pick up the children from daycare, and when they were out, maybe they would speak to a friend or speak to whoever they see when they're out. But those opportunities have dwindled during COVID, obviously. And just to say, it's not always a simple determination for people to decide to leave an abusive situation or to report an abusive situation. There are a lot of things that impact that decision, whether it be economic dependency, or whether there are children in the family, or just various reasons that I'm not going to list out today, but it is complicated, as is the intersection between family law and domestic violence. Sometimes that intersection is quite complex. So again, it's always best to speak to a lawyer about these issues to get advice, preferably a skilled family law lawyer who understands this interaction well. So as I said, I'm going to post some resources in the chat after, and most of them are free of charge. There's some virtual legal clinics for people experiencing domestic violence. I'm also going to post the link that will take you to Legal Aid Ontario. In case you're unable to afford assistance, you may be able to apply for legal aid that way. I don't know if Richard or Roz, if you have anything to add about the domestic violence piece.
I would just add that, it is certainly exacerbated during COVID, and that if you do need resources that you look to the list that Dan is going to post at the end. There are resources out there, and actually legal services provided by Zoom are helpful, provided you have a connection or can use your phone in some privacy. Obviously, that's a challenge as well. I'm going to change to a different topic, and noting time, I'm just going to take it on and do the whole thing, if that's okay with my co-presenters. It's on vacations and travel, which may seem like a happy topic, but I think during COVID and as borders are opening, this will become an issue, especially with children who are primary school age who cannot be vaccinated, which then as well poses a host of issues as well, where the parents aren't on the same page about things. I think suffice to say, it will be an issue, and it's if it comes up, not to be surprised that it comes up or think that your situation is somehow unique or otherwise. And so the push and the pulls are, one, where people proposing to travel with children or even without children. So if a parent is traveling and then returning, what are their obligations to quarantine, self-isolate, and therefore perhaps forfeit some time with the children until they are cleared of testing and so on. And again, common sense should prevail. It's different if you're going to a destination where there are low number of cases and that there's not going to be a lot of social contact versus you may be going, to a stadium of 100,000 people. I think that would be a different kind of situation. So again, you may think I've got to jump out and see a lawyer and get some advice, and the lawyer may help you troubleshoot it. But I think it also behooves the two of you to talk about, what makes practical sense. It may be have a longer visit before the travel if you're not traveling with children, or if the children are going, if they're not vaccinated, I think that's going to be an issue. And even the quarantining, I'll tell you, in terms of the courts, I just saw a decision yesterday where a judge would not let a child travel to California to visit the child's father, and that one parent lives here and one parent lived in California, for the regular sort of summer visit. It was going to be an extended visit, and because the child would have to quarantine on the way back for 2 weeks. This was just before the new travel changes, but when the child returned, would have to be in self-isolation or quarantine for 2 weeks. The judge said, no, it's not a good time to go. I personally could see different arguments on both sides of that, but these are the things that, if you're trying to grapple with, imagine a judge trying to grapple with your family, you're probably better off to try and work it out yourselves. In terms of knowing, be aware of where you're going, what the numbers are, what the exposure might be. And the last thing I'll mention just on this quickly is about insurance, travel insurance. You have group insurance that you think will help cover you. Again, you have to check that out, because if it's non-essential travel right now, there are some travel plans that are not going to cover you. So you may think you're covered, but because you've gone somewhere and we aren't quite out of the travel restrictions, your coverage might not apply. So that's something for generally everyone to check on. And that's all I'll say about vacations and travel, COVID.
So Roz, let me just amplify a couple of the key points you raised, and it's not really a legal analysis. It's with respect to these things, it's very factual, right? So when you say try and work it out with your former spouse or former partner, that is really the key. Communication, common sense, reasonable positions. You'll get much further along, I think, employing that strategy than necessarily rushing to the lawyer or rushing to the court. But I think you covered all of that perfectly.
So
okay.
So
ahead,
I was
Dana.
just going to pose another question. Roz touched on vaccinations briefly in her comments previously. So, I think it's on the horizon more so than it is now, because now it's children over 12 who are approved for the vaccination. But, as we all know, it's likely going to be offered to children younger. And I think the disagreements between parents about whether to vaccinate their children, specifically with respect to this COVID vaccine, I think disputes will arise just necessarily as a matter of course. So I'm wondering if, Roz, if you wanted to touch on that.
Sure, I'll throw out my initial thoughts and then Rick, you can weigh in. First of all, for children who are over 12, they have some say in whether they're going to be vaccinated or not. So it's not just up to the parents. And there are some kids who are well aware that they want to get vaccinated, some who are well aware that they don't want to get vaccinated. So I think in that sense, if the parents are in agreement, but not with the child, there's going to be one kind of discussion. If two sets of the parents are on opposite sides of it, but the child has the sort of say in it, then we could see what might happen. So that's one thing. But as for children who are primary school age, I mean, it's not much. These cases are, not as prevalent as they might be for other kinds of vaccinations, but they do happen still. And there may be religious reasons or other, reasons based on other valid grounds, such as, fear of other health reasons or health effects if they're pre-existing circumstances or risk factors for the child. Those things will still be relevant, I think. So if you have someone who's immunocompromised or for other reasons, they might not want but you're going to need medical evidence. What it comes down to is you're going to need some doctor to support whatever position you want to take. So no, Johnny shouldn't get this vaccination. He's had a prior history with respiratory and shouldn't get this, and here's why. So that is generally where the case law has gone with respect to justifying one position or not. There is a sense, I would say, a bias towards vaccination for COVID, I would think, and other vaccinations, because of, I think, the kind of nature of this epidemic. Right.
What I would add to what Roz said, and I agree with everything she said, is that judges are very cautious about displacing expert opinion, right? And expert opinion says today that people, if they can be vaccinated, they should be vaccinated. Right. That's what Health Canada says. That's what the provincial and municipal authorities say. And it's also what, for the most part, pediatricians are saying. So, it's very rare that a judge would impose their own views over that. But if they do, you better come to court with very specific medical evidence why your child shouldn't adhere to the general regime that's being suggested by the government or the healthcare authorities. But other than that, I think, and I was just called on this the other day, it is best, echoing my comments about travel and special occasion or vacations, it is best if you can figure out a solution as a family, right? And this is a discussion with kids, right, about where people are on the vaccine and why, and get everyone's agreement on something like this. Because people, do sort of self-help measures and take matters into their own hands and take the kids to get vaccinated, maybe without the consent or knowledge of the other parent. Those things do happen. And once it's done, it's done. But the idea is, I would hope that people could talk about this and get to a mutually agreeable resolution without taking unilateral action. But yeah, definitely when you were talking about, kids 12 and over, they have a say under the Healthcare Consent Act. And it's important that, their voices be heard, and there are considerations where children align with a parent's perspective, maybe because they've been told to do something, and inquiry should be made if that's the case. But otherwise, I think it's important that everyone sort of have a voice in that. So that's all I'm going to say.
Yeah, I just wanted to add, and this is more of a blanket comment about all of this COVID stuff. And you may not think that that this impacts on the kids. So you may think that, we're just arguing about vaccinations. We're just arguing about in-person school or online schooling. We're just arguing about whether to, travel, or whether we could take our kids to the grocery store or not, or keep them inside. And although we may say, keep the kids out of it, it's difficult to do that, and you're all inside the house together. But I want people who are thinking of this, and especially people who think this is a positional kind of discussion, kids are going to be affected by it. And I see that kids we're missing out on the kids' perspective about COVID in general. Lots of kids are anxious right now, especially at the beginning, or we're at the beginning, about, am I going to die? Is mommy going to die? Is daddy going to die? And when you have this kind of conflict about other stuff in their earshot, you're just amplifying that. And so it's not going to be just, well, once we decide on vaccinations, our kids will be fine. Like, at least one way or another, kids will be fine. The whole conflict about it, or the whole discussion about it, actually will also have a longer term effect, in my view, on kids, about vaccinations in general, about what to do when there's another pandemic or another illness, whether we should be scared of going out in public, or scared of going out to school in person or online, whether I have to stay online. And I think we ought to think about these things, because in family, although we're in family law, this COVID and the effects on children and parenting among even in intact families, I think we're missing a bit of the effect on children. We think that they're kind of just little floating around in the water, and we just push them here and push them there. But they are taking in a whole different view about co-parenting and being parented. And so just keep that in mind. It's not just one issue. It's not just a little issue. I think the next thing is about accessing court and legal services that we wanted to touch on. And just to maybe give people who aren't in law, or even lawyers who are in different fields, some kind of idea of how family courts have adjusted to COVID, and what you might be looking at if you were to want to engage the court to deal with any kind of actual family law matters right now during COVID, whether they're COVID related or not. Rick, what have you found in terms of significant differences since COVID started, and how the courts operate? You can start there.
So I can speak to my perspective working with the Ontario Court of Justice in Toronto at 47 Shepherd. And probably much like most courts, there was an initial stoppage of work. The courts weren't operating at full capacity, and we didn't know what was happening with the pandemic yet. But very soon after, they began telephone operations where, if you had something to deal with the court, you could call in and you would have a conference via teleconference. And soon after that, video conferences started to come to the fore. And, I'm doing the vast majority of my work now on Zoom. When I'm in court, I'm on Zoom. Certainly there are instances where the courts, I think, are inviting people back into the physical courthouse, but I think those opportunities are limited, and I would suggest that sometimes it's a hybrid approach where some people are invited in if they feel comfortable, and some people still prefer to Zoom in, but you see that sometimes for trials, I think, more often than not, where people are asked how they feel about having a trial in person versus on Zoom. One of the pieces I was most interested in was silver linings, and what is sort of that in terms of, there's very few silver linings when it comes to COVID-19 or the pandemic, but I think one of them is the embracing of technology. And something we hadn't seen before with the courts, and that is people are able to now, at least the court I practice in, get very specific times for when they're in court. So you call in and your Zoom time is 10 o'clock. You will be heard at 10 o'clock. And your appointment is a 30-minute appointment, and then there's somebody else lined up at 10:30. So you don't spend your whole day in court anymore, and that was a significant problem for a lot of litigants, where they had to take the day off work and they had to arrange childcare for their kids. And a lot of my clients, if they don't work, they don't get paid. So it was very difficult. But now, they have a 30-minute window where they know they have to Zoom in, and after that 30 minutes, it's done. So they can get back to their work or taking care of their kids. And certainly it's a more comfortable surrounding for most people, right? Going to the courthouse and actually being in the courtroom is not a comfortable place. So if they can Zoom in and participate, and often my clients have said to me, they feel lucky that they're able to have access to the courts in this way, because they don't feel as intimidated, they don't feel as anxious or uncomfortable. And it actually has worked for some people that I've talked to. So that's something interesting, and I hope the court will consider keeping that after the pandemic. That maybe we can do these conference calls or video calls. I think it is challenging for some people in terms of getting with the technology. But most of my clients have been able to do it successfully. So, I think there's some preparation involved and some training involved for some people. But again, people who weren't necessarily comfortable with technology have been able to do it. And so I've been very pleased with that piece of the sort of COVID story.
I'll jump in. I think, yes, I'm just continuing on silver linings. I think it has helped with as lawyers to represent clients in different jurisdictions as well. So there's more, perhaps, I guess, access to the lawyer that you want, even if you aren't in the same jurisdiction. On the other hand, the courts themselves and everyone's doing the best they can, but I think it is quite evident to the lawyers in this area that the courts are not able to deal with as many matters with a Zoom kind of platform. I think there are less resolutions happening, which used to happen in the courthouses, in the hallways, while you were waiting all day to try and get things done. But the face-to-face aspect to it with both clients and lawyers helped to resolve things even before you got into the courtroom with the judge, and that has been lost. And I think that kind of loss, then what it does is it puts more pressure on the courts to deal with their 1 hour slots. Some judges are doing great jobs with still trying to maintain the kind of sort of conferencing type of role and saying, okay, you guys go over here into a Zoom room and try and work some things out and come back, and they're still trying to do that, which is fantastic. It's more difficult though. So all of which to say is clients are frustrated, lawyers are frustrated for their clients, and clients are frustrated because when you now say to your lawyer, can't we get into court to deal with this? I think this is important and urgent. The standard of what is urgent is a very high threshold right now. And so formerly, where I might have said to a client, yeah, you know what, we do need to deal with a school is coming up. We need to figure out where we're registering for school. I can't be sure right now, if we're in July, that I'm going to be able to get that heard in any meaningful way before September. And then what happens? There is a push on, of course, for alternative dispute resolution, such as mediation, arbitration, which I think is one area of family law which is probably going to have to grow, because even when COVID starts to subside a bit, there is a huge backlog for matters that just can't be resolved by negotiation, and there are those things in family law. So they put a tax on the system, which sort of backs things up. So for clients out there who, it's not that lawyers don't want to help and don't want to try and resolve your issues, but where we try and say, we have to look at a different route here, it's out of some recognition that the court system itself is just not equipped to deal with all of these things, all of the demands right now. So that's one thing that I think has been a harder part, and that it does affect access to justice for people, because you can't get interest. There are power imbalances which require the court's intervention, and I think some of those are getting sidelined because and in other ways the courts are being used because you can't get into court as a way to continue certain power imbalances. So it's difficult. And so I think yes, some good things have come out of it. They'll create some efficiencies. In family law, my personal view is that you still need sometimes face-to-face, you still need people to have to make the trek to court to understand the gravity of the situation and do some serious soul searching about, do I want to keep showing up? And sometimes the convenience of Zoom, it loses the kind of importance of, we're dealing with children or we're dealing with serious financial issues. And it's like, well, I'm going to watch Netflix after I Zoom in. The judges, I think as well, may be a bit frustrated about sometimes how they can't get as much done as they used to. Dana, what about the FJC, Family Justice Center, is designed to help with filing court documents and pleadings, which was something that even before COVID was important, but especially in COVID, to navigate that. How are you, what kind of comments do you have about electronic filing and documents filing?
Well, I think another silver lining might be the fact that in family law, we are now able to file court documents electronically, which, believe it or not, we might have other lawyers who are attending who operate in other areas of law who've been doing this for some time, but this is brand new to family law during COVID. I think that pushed us in a good direction. So we have a portal. Some courts also have individual email addresses, but I think there's a push towards this portal, and I'll post the link in the chat in a little bit. So people can file their own documents, lawyers can file documents on behalf of clients through this portal. Just a note, if people still want to file in person, sometimes it requires it if you have a brief of documents that can't be filed electronically or something like that. You can file documents in person at courthouses. Just, I would be mindful that sometimes courts have limited hours, or they're only accepting in-person filings at certain times of the day. So it's always best to check beforehand so you don't end up there having to turn around and go back home. And some of the things to just look out for with the electronic filing, I think, sometimes I think we get used to just habits that have formed. And I know that when I was practicing, sometimes if a document needed to be filed late for whatever reason, it would be a pretty straightforward thing to get the other side's consent, get the court to approve that. But with the electronic filing, that's not easily or always or even usually the case. I think that generally filing dates are pretty strictly enforced now with the electronic filing, at least in the courthouses that I'm most familiar with. Also, page limits are strictly enforced. So if a case conference brief is supposed to be, I'm making up a number, 7 pages, it will not be accepted if it's 8 pages. Same with attachments. So just all these things to be mindful of, because sometimes if you try and file something that's too long, you don't realize until it's too late once they send it back to you that it hasn't been accepted. So all of this to say, it's really important to refer to the practice directions from the local courthouses that you are going to be litigating at. I'm going to post another link that will have it's sort of a consolidated collection, or a collection of court notices, just so you're able to make sure that you're adhering to the rules at the specific court. So be very mindful that a practice, even in the courts in Toronto, there are 3 courts in Toronto, the different rules, there are different rules that apply to each 3 of them. So just be mindful of that, so you don't, you're not surprised by your court documents being rejected. Yeah, I think that's it about the electronic filing.
I'll just add one thing so people are very clear. There's actually sort of 3 levels, right? So there's the family law rules overarching that, are provincial, right? Everyone has to adhere to those province-wide. And then there's, the Superior Court of Justice has their own set of directions and rules, as it relates to their court. And the Ontario Court of Justice has, can set out their own practice directions. And in addition, so that's sort of the second layer. And in addition to that, each courthouse has the ability to make their own administrative rules to process things as they see fit. So there's actually sort of 3 different levels one should actually turn their minds to when making sure they're adhering to any procedural requirements that they have to do.
It's not easy, and it's not been easy for even lawyers in the profession to do it. Sometimes we were getting practice directions once every 2 weeks, and for different jurisdictions. So I do empathize and sympathize with self-represented litigants. So there are resources out there. The CLEO as well, the Community Legal Education, the Ontario, has lots of good actually online resources to guide you through, as well as the Family Justice Center and legal aid. But it is a strange time, and it's always a strange time to co-parent or deal with family law issues because of perhaps the emotional part of it as well. And so with COVID, it has added to it. But I do think, as Rick has said, a lot of good things have come out of it. The Divorce Act has also been changed during, and the Provincial Act during COVID, it was coming out anyway, but to encourage using things like mediation or arbitration, if possible, to keep you out of court maybe in a more private kind of environment, but to also have more skilled practitioners trying to help you resolve your files. The court has always had a dispute resolution officer program that Rick does as well, where you can, that continues during COVID to help people kind of resolve things without having to be right in front of the judge. So those things are still in place. Should we move on to our last scheduled topic, which is about child support or income issues, which, and I'll just say this and then throw it out to the two of you, or to Rick or whomever. I think that we all expected that COVID would have led to a floodgate of motions to change what we call motions to change child support or spousal support or things like that. I don't know that it has so much because perhaps of the government subsidy SERB program and things like that, which have helped. And some businesses have done really well during COVID and some others have not done so well. So it's a great, it's a time of a lot of change with respect to business and income and otherwise. But maybe I'll start with Rick. You know, have you seen a lot of motions to change or people wanting to deal with either temporary or more permanent changes to income?
I think you're right, Roz. I have seen some, but not a sort of a avalanche of them, which is what we all expected. And yes, I believe that some of it has to do with businesses being able to pivot during the pandemic to still keep in business. Some of it has to do with government programs that have helped a lot of people. But when people do come see me about these changes, the first thing we look at is, is this pandemic related? Is this a permanent change? Is it a temporary change? If it's temporary, what's temporary? How long? Do we really need to go back to court to change the order or change the agreement? Or can we just put something in place on a temporary basis as between the parties with the understanding that, there is a short period of time where perhaps something could be changed or reduced. It is complicated, especially if the Family Responsibility Office is involved. Because if they are enforcing, they can only enforce the agreements and orders that have been filed with them. So it's incumbent upon people to change those orders or agreements if there has been a change, and you have to do that in court. So it is difficult. So what I would say is I think good change is coming. Right. And if people can sort of hold off, I think, there's going to be sort of positive things in the near future where, we see people in the hospitality or restaurant industry getting back to work. We see other industries picking up again. So hopefully people won't be in a position where they feel they need to go to court to make these changes. But, as with all the advice today, I think the first line of defense is speaking to your former partner or spouse and talking about what's happened, and give them the disclosure, right? If you've had a downturn, show them that, right? Show them your new pay stubs, show them, what the change has been, that it's been a significant or material change. People understand. That's what I would say.
I'll just layer on that the courts approach it the same way. So you can play silly bugger and either try and claim you have a reduction and want to reduce your support, but if it's temporary and it pops back up and you've wasted everyone's time by going to court, the judge can ding you on that. And likewise, if you're not somewhat responsive to the fact that the other spouses has an income change or decrease during COVID and tried to accommodate that and made the person go to court or made the person go to change the order formally, just because, you could be hit with costs as well of that other person. So that the court retains that. And I sometimes suspect that the judges will want to use that because that's one way of keeping people outside the door. And if they know that there are going to be cost consequences for not being reasonable, then that you might not take a swing at it and make somebody go to court or have to go to court.
The only thing I was going to add just to Richard's point about, you brought up FRO, the Family Responsibility Office. That's who enforces, our government agency who enforces support orders. Payors, I know at the beginning of FRO, or the beginning of COVID, sorry, there was a push to in order to stay out of court and lessen the court's load. If you were a payor and you wanted to decrease your support, you should call FRO. Who they can't decrease your support. They can't change the order that they're enforcing, but to come up with a payment plan specifically with respect to the arrears that have been accumulating. Sometimes there's the ability to negotiate with the FRO worker to do that, which might just turn the temperature down a little bit every month until, things can be reinvestigated once someone's income hopefully goes back up to pre-COVID levels. So that's just in the spirit of being practical and reasonable and just not rushing to court. I think that's another one. I think FRO, I've heard, is now taking more enforcement measures than they were at the beginning of COVID, and being a bit more, I don't want to say aggressive, but active, maybe pursuing those cases. But it's always still, if you're a payor and you're looking to decrease support and you've got some arrears that have accumulated, I'd start with FRO and see if there's anything that could just temporarily address things enough.
We have one question here, which I'll throw out there. The question is, what happens if, due to a prior contract or agreement or past conduct, one parent has traditionally had the medical decision-making authority for the child? But I assume the question is if there's something COVID related, either vaccinations or what to do during COVID because of health issues, how would a court respond? Right?
Well, the court always retains jurisdiction to make an order with respect to children, such that, irrespective of who sort of had the decision-making authority with the prior court order or agreement, the court can impose their view such that they can change who the decision maker is for medical reasons or for all reasons, right? But it's not it's not cut in stone that once you have decision-making authority that you can keep it. Again, if you're engaged in reckless behavior and you can show that to the court that the decision maker is not making decisions in the best interests of the child, I think a court won't hesitate to switch it and make the other parent the decision maker. But again, it would have to be within the context of this particular family and what's reasonable and what people can prove in a courtroom.
Right. And I think you need, as we said earlier, you need some medical evidence or other evidence of what is going on. And it may be that they don't change the whole arrangement of decision making, but the court may intervene and say, for this particular decision, this is what's going to happen. And that happens often with schooling decisions as well. And it may be the in-person schooling versus the online schooling issue. I think similar type of question where one parent has the decision making for education. Is that an education decision purely? Is that a health decision purely or not? And so those kind of matters have gone to the courts, regardless of what the status quo is or agreements are with regard to decision making. And the fundamental test is best interests of the child. So if this child doesn't do well at home, sitting online all the time, and there is the option to go to school and it's fairly safe at the school, and all of the protocols, that's what's going to be considered by the judge, not just parent A has made that decision in the past and this is what they think is the best for the child.
Yeah, they'll take all the considerations into account in terms of, the child's physical health, the child's mental health, their psychological and emotional well-being, and not just, and also, of course, being able to see and continue a connection with both parents. That's always very important.
Maybe with a few minutes we still have in there, if anyone has any questions, what if people, maybe someone can describe what mediation is as a method of dispute resolution, because some of our attendees may not understand what that means. With and without counsel, on their own, who does it? How do you find a mediator?
I'm happy to share some resources in the chat after, and I can just start off very generally. So mediation is when you and your former partner choose someone who is a neutral third party who is trained, and they will help you. The goal is to help you to navigate and resolve disputes. So sometimes people will bring all of their familial issues to them. Sometimes it's just a one issue that just can't be resolved, like who has the children for Halloween or whatever it is. And you just direct that specific dispute to the mediator. The mediator themselves, they might be a lawyer, they might be a social worker. You can sort of hire based on your needs. If you have financial issues, you should probably hire, my opinion would be to hire someone who's trained in family law, who is a mediator. And if you have more issues based on children, best interests, those types of issues, either a lawyer or a social worker who is a mediator as well. And there are lots of subsidized programs in Ontario. And once I stop talking, I will find those links and send them through in the chat so you're able to find them. But there's sliding scale, there's free, there's court associated mediation services. Richard, you probably want to comment on mediation.
I was going to say, Dana, that it's my understanding, I could be wrong, but I think the government does support court-connected mediation in every courthouse in the province. So it doesn't matter where you are, you should be able to find some kind of mediation service. I know in Toronto, we're very lucky. We have 3 courthouses and very strong mediation services at all 3, very skilled mediators. I'm a big believer in mediation, you know, I think a lot can be accomplished using mediation. And again, what I tell people all the time is although judges are very specialized, very full of wisdom in terms of kids, I always believe that parents are in the best position to decide what's right for their kids. And with the help of a third party neutral like a mediator, they can do that. So, you know, assuming, you know, there's no reason not to mediate, I'm a big proponent of it.
And Dana has posted the 393 Mediate, which is Toronto per se, but they are in all courtrooms. And I don't actually think you have to have an ongoing court action to reach out to them and ask for somebody to help. And it's a sliding scale. These are family law mediators. They can do it with or without lawyers involved, sometimes better without lawyers involved. And so encourage that. But that requires you to take some control over the situation and not just defer to a court system or lawyers. Lawyers will give you good advice, I assume, and tell you that what you can and can't get done in court in a short order or what needs to be done. So mediation, especially with specifically trained family law mediators, is going to be at least helpful, and especially at subsidized rates if that's something you need. So for sure.
And even if you go in without lawyers, sorry, Roz, but if you go in without lawyers and you negotiate a potential agreement, you can get, best practice would be to get independent legal advice from different lawyers with respect to the agreement. Not all people do that, but that is probably the recommended course of action. So if you're worried about navigating it without a lawyer, there's always that safeguard at the end if you wanted to get the legal advice at the end of the process.
We're almost out of time. The last thing I'll mention is something called unbundled legal services, which is what the FJC does. There are practitioners, lawyers. There's, if you Google unbundled legal services, there is a Law Society website. Lawyers provide those services. They don't your lawyer for the entire duration of your action, but they, if cost, obviously, I can't see why cost would never be a something you'd be concerned about, but they might be able to give you advice, to help you draft documents, to help you with the steps that might be needed to get, if you need court assistance, or even to help you with the negotiations.